multi-page, and they had all sorts of seals that fell off and so on. In 1984, they went to the new streamlined version. Then the introduction of title insurance, it only really came into Canada in any meaningful fashion in the late 1980s and early 1990s. And then electronic registration came around in the early 2000s. So in a little over 2 decades, everything changed that hadn't been, for 200 years. I mean, the Registry Act was 1795 and the Land Titles Act was 1885. So nothing changed really for almost 200 years. Big changes. So title insurance, it was a big change because as lawyers practicing, we were aware of title insurance simply as an American problem. Right? We had clients who bought a property in Arizona or something, so can you act and go, okay, the title insurance. So when it first came in, we had no idea of the coverage. Basically, all we knew was mortgage instructions would show up that would say you had to have a new survey of title insurance. And as you know, people are incredibly cheap, so they always went for title insurance because it's less expensive. And we did everything else regardless. We still gave title opinions, we did all the work, and really didn't have to. We'll get into that in a sec. So I think the best way to if you're thinking about title insurance in a given situation, it's intended to at least initially mimic the kind of protection you get from a lawyer's title opinion. Right? So the lawyer investigates title and then gives a title opinion at the end of that. And that includes not only looking at the actual registry documents in the office of the land titles office or online, as the case is, but also doing all the municipal reports, maybe getting a brand new survey and so on. And then they give a title opinion, which is subject to exceptions and things like that. So title insurance initially is intended to kind of mimic that, and we go beyond. Okay, so if you look at the paper, and there's a lot of interesting information here.
Sorry, can I interrupt you for 1 second? Can you speak louder? It's very difficult in this room, and it gets.
Or maybe we could just move them closer to the microphone. Because
I was going to sit there, but they said,
Well, because I didn't know if you wanted to back to the screen.
Oh, it doesn't matter. It doesn't matter.
it's the male deep voices are really hard to hear.
The male voices get lost in here.
Because it's the lower, I don't know why.
You speak of a higher pitch.
Sorry. You are speaking a higher pitch. Thank you, sorry.
no worries. Okay, so if you look at the paper, it has a lot of interesting background information that you probably care about, but this is from different audiences. Compare a solicitor's title opinion to title insurance. So they all cover title protection, right? That's what the lawyer's opinions would say at the end. They talk about off title protection, so there's various things like executions, judgments against zoning, work orders, open permits, etc., etc. And the coverage continues as long as, for a lawyer's title opinion, as long as you own the property. But it's nothing that can be transferred to anybody else. In other words, if you transfer it to your children, it doesn't continue and so on. It just continues as long as you own the property. The minute you sell it, then the opinion is gone. So we're able to go beyond that because we're an insurance product. So we're not limited by searches and so forth. We take risks. One of the things I used to hear quite often from clients before title insurance, I'd say, well, there's this issue and that there's nothing I can do about it. Are you going to take title? Are you going to take time and say, well, what are the risks? What are the chances that this is going to be a problem for me? And my standard answer was, look, I'm not really agreed. I don't know. Right? I can't tell you what may or may not. We are in essence, we agree. We look at things, we decide, and we take risks. So one of the things that, and I mentioned this just a few minutes ago, that made title insurance popular in Canada and across Canada, as it turns out, is the survey coverage. Because surveys were very expensive. Even back in the 80s, they were $800 now. Most areas, to get a survey on a full lot on the registered plan subdivision, probably anywhere around $2,000, $3,000. Okay. And of course, people are cheap, they were cheap back then, they're cheap now, so they're not going to pay it up. So survey coverage under title insurance policy covered a lot, and it is really good coverage. Basically, to boil down what's in the paper, it covered for things that would have been revealed by an up-to-date survey when you bought the property. You're not covered for things that you would have put on the property subsequently. You can't build an illegal structure and then make a claim, and you created that. So that's, I think, a huge benefit of title insurance. And when you look at the fact that in most cases, title insurance is hundreds, depending on the value, it's keeping the value. Well, in a really high value market, it might be a couple thousand. It's good coverage for what you get. And then, of course, one of the things we're going to talk about today, fraud, forgery, and false impersonation. This is something that's really new in real estate. I never heard of fraud before the turn of the century, and it only became really apparent, I'd say, in the last 10 to 15 years. And it's been getting worse all the time. A lot of people have tended to blame it on e-reg, electronic registration. I don't think that makes any sense whatsoever, because in order to get into electronic registration, you have to get vetted, you have to get a key to get into it and so on. Whereas before that, you could have just gone to Dye and Durham and bought a bunch of mortgages and gone to registry. So I think it's more about society in general and technology, but it's a huge issue. We just did a program yesterday for lawyers. We had a panel discussion with about 6 of us talking about fraud. I'm sure you've heard in the news, there was a ring in Toronto area that did about 30 of them. But we see them constantly. And from one year to the next, they go up and down. They're never in terms of volume huge, but they are in terms of the money that we lose very, very large, because they're complete losses. If somebody registers a fraudulent mortgage, well, they're gone, the money's gone. There's very seldom any recovery on any of these things. So that's gone as well. And we'll talk a little bit about, after I go through these, about fraud coverage and the type of things that happen and so forth, because we've been getting an incredible amount of calls because of all of the publicity that's been going on. And we do have products that deal with that for people who may have never had title insurance, but that's something we can do a little later. So those are two of the big advantages of title insurance off the bat is the survey and the fraud coverage. And there's also coverage for errors in public records. So, we still require lawyers, all title insurers have pretty much the same requirements to do title searches and so forth. But if there was an error, then you would be covered. So for instance, it's not unusual to pull a parcel register and then see on it a little note saying deleted an error by so-and-so reinstated. And we've even seen that on mortgages, liens, and things like that. So it's possible that you could get a bad search and then have it later. And the registry office's response to that is simply to shrug and go, "Oh, tough." So we cover those type of things. And even if you get tax certificates and zoning reports, if they're wrong, they give you the wrong information, then we cover for that. There's various types of properties you require a little bit more due diligence and background. And of course, one of the advantages is it's no fault. It's an insurance policy. You submit proof of loss as required, and then we review it. If it meets the criteria, we pay you out. Whereas if a lawyer gives you a title claim, then typically you end up having to sue the lawyer. You have to start an action. You have to get the lawyer's insurer, which is Law Pro, to come to the table, and that can take time and cost money, and it's much faster and easier. And we understand people make errors. It's human errors. Lawyers are human. Believe me. Some people don't think so, but we make errors. That's why we have the insurance. And it's also question of permanence on death or disbarment or retirement. So I left practice 22 years ago this year. The way the Law Society and Law Pro look at claims that are made, the insurance that would respond to the claim is the insurance that's in place when it's discovered, not when it occurred. So if I made an error 30 years ago and it comes to light now, the insurance that I paid for back then doesn't have anything, it's what I have now, and as lawyers, when we leave practice, we only have $250,000 in law. Yeah, so that would pretty much cover a garage or something in the GTA. So unless you want to turn around and pay outrageous premiums for it, then which normally doesn't happen. Whereas title insurers, we're an insurance company like any others we have. We're heavily regulated. We're regulated by the province because we're dealing with real estate, and we're dealing as an insurer, and we're regulated by the federal government as a financial institution. So we've got people on us all the time. They tell us we have to up our premiums or we have to increase our reserves and so on. So there's always money there to get, no matter what. I have the last company that went under, I think was 20 or 30 years ago, and I think it was Confederation Life or something. But it's something that just doesn't happen. And under the policy, we have a duty to defend your title. And this is really where the fraud coverage comes in. Because once you have title insurance, we have to defend your title. And so if somebody registers a fraudulent mortgage or registers a fraudulent transfer, then we have to respond. A lawyer does, and the lawyers, once they've given you a title opinion, if it's September 30th, and there's a fraud a month later, excuse me, they don't have any responsibility because that doesn't fall under their retainer. The title insurance coverage is post policy as well. So the duty to defend kicks into that. And we have the ability to cover over known defects. And that was a huge problem before title insurance because we could find relatively minor issues, zoning non-compliance or small encroachments, say by the garage on the neighboring property, and the deal wouldn't close. Because all we could say as lawyers is, what are you willing to accept this? And the lenders would go, no. And the clients would kind of puzzled and go, what does that mean? So the deal wouldn't close. Now we got our risk. And now we analyze risk, look at it. So that we have a big underwriting department that we cover all sorts of things all the time that allow the deals to close. It's very unusual not to. And there are certain types of unknown defects that we cover, for instance, reassessments of taxes. Right? We tell lawyers, look, if you're buying new houses, at some point in time the taxes are going to be reassessed on the property, and they're going to be backdated to the time that they moved in. So you should make an attempt to find out what they are, kind of ballpark them, and have a whole back. But if that doesn't happen, then we do cover off that. And we have inflation coverage in the policy. So if you buy a policy for a homeowner, then the policy amount is the purchase price of the property. But it was until very recently a 200% inflation improvement factor in there, so it would double over time due to the property values rising and perhaps improvements made to the house. Now it's 400%. So it should be okay for the foreseeable future. I don't see them inflating that much, but I think wrong. And there are some advantages that are specific to lenders. I'll just kind of go through those quickly, but they love the fraud protection as well, obviously, for third-party mortgage or even lawyer fraud, if a lawyer absconds with the money, etc. What we basically say for lenders' policies is very straightforward. We guarantee the validity of the mortgage. We guarantee the priority. It'll stay there whether it's a first, second, or third mortgage. And we guarantee it's enforceable against the property. What we don't guarantee is value. That's up to them. Right? So if they give a mortgage on a property for $500,000 and it turns out it's only worth $300,000, that's their issue, not ours. But basically, we cover anything that would affect that. So a lack of independent legal advice for one of the mortgagors or ineffective legal advice. We've even covered post-closing alterations by the mortgagor. So it was a situation I recall where property had been purchased a mortgage and the people decided they wanted to do some renos themselves. Of course, they watched the HGTV and decided they'd be experts at all of this. And they started banging and tearing down things and didn't get permits. Why would they bother doing that? Then they got into a big argument and one took off, the other left, and the house was vacant for a while. It had been pretty much demolished inside. And when started doing power of sale to possession, they went, oh God, we're not gonna be able to sell this. We cover off that because it was work done without a permit, so it falls under a specific heading. So banks like title insurance, and we have gap coverage. And that simply means that the registry office closes, is it 6 o'clock now or 5? Okay, so if the parties are late in getting funded, which happens all the time now, and all of a sudden they're past 5 o'clock and they can't close, as long as everything is in order, all the documents are signed, all the searches are up to date, everything else is okay, we allow them to close so they can exchange keys and documents, and they have to register the next business day as soon as possible. If anything is registered in the interim, be it a lien or an execution or another mortgage, then they're covered on. So we're very pro closing transactions. And it's assignable. So you can take a title insurance policy. First time home buyers tend to, at least at one time, maybe this has changed to a 5-year mortgage. At the end of 5 years, they may go somewhere else. That policy will transfer if the mortgage is assigned. If it's not discharged, it could last 25 years. It could be assigned again and again and again, all the way through. So it makes it a lot less expensive. And, that enhances their mortgage portfolio, excuse me. So again, so that's, all the great things about title insurance. And I'm going to tell you about the limitations, because I think this is probably more important. We don't cover functionality or quality. We don't guarantee the house is built properly, that that the roof isn't going to leak, the basement is going to leak, any of those things. It's just not covered. Unless, and that's the big caveat, unless they're somehow linked to a legal defect. So in other words, if it was an open building permit, and that was the cause of the issue. So it's something that could have been discovered. Okay. So you can sometimes get people coming and saying, well, I've just had somebody look and they say this wasn't done to code. Well, that's not our function. We're not a quality assurance. If it was an open building permit or a work order or something like that, then there would be coverage for it, but otherwise, no. Because if we were covering that type of thing, we'd be charging a heck of a lot more than we do. And there's a limitation on native or indigenous land claims. We do insure some properties on indigenous land and so on, but they're very specialized. But if there is a claim made, and apparently all of downtown Toronto and the islands is subject to a claim, we don't cover that. That's something that's going to have to be worked out by the feds and this is the other big one, environmental contamination. Don't cover anything to do with that. So it's not typically that big a problem for residential properties. It's more of a commercial property, but there are areas in Ontario, fairly Guelph, Aurora, and beaches are termite areas. We don't cover that. We wouldn't cover different types of insulation in there, or mold. That's one of the things that, of course, you have to be concerned about on former grow-offs, is the toxic mold that may or may not be in there because of the high humidity. We don't cover anything to do with that. So anything environmentally related, no coverage. Water potability and quantity, we don't cover that. So if you're obviously on city water, that's one thing, but if you're out in the country and you're on the road and so on, obviously you've got to monitor that on an ongoing basis and perhaps install a filtration system because you just don't cover that. I used to service when I was doing what we used to do, the Waterton area and other areas, and they had huge issues with that because they had 2 morons running their it was a public system, but it was dealing with deep wells, and they had 2 brothers that didn't know anything running it, and they got basically everybody got this sick. They had a lot of them got, so no coverage on that. We don't cover the legality of rents. So if you're buying an income property, we don't cover that. It's nothing to do with residential tenancy legislation, anything like that. That's something that the lawyers would have to look into. And there are specific requirements for multifamily properties. So residential title insurance, and I think this is true across all the title insurers that I'm aware of, is limited to units. If it's more than 6 units, it's a commercial policy. They're quite a bit different. They have less coverage in the actual policy. Most of it's built with endorsements that are added, but it's much, much different. So if it's a residential 7-unit property, commercial, if it's a mixed use, it's also commercial. So if you've got a situation, excuse me, where the bottom floor is, say, stores, and above that is residential units, it will still be considered commercial. We don't cover channels. So obviously, fridge, stove, washer, dryer, none of that's covered. Future use considerations. We look at the agreement of purchase and sale. What does it say you're buying? Did you buy a single family house? That's what we cover. You may want to change it to multifamily, but it won't guarantee you can change it, nor will a lawyer in the absence of specific instructions. So nothing to do with that. And there is a limitation on survey coverage, but it's a necessary one. We don't cover the cost of moving fences and boundaries. Because if you were to go into a given subdivision and survey the properties at random, I would pretty much guarantee you that the fences won't be on the wall. People very seldom ever have a surveyor come out, monument the corners and run a plumb line when they put the fences in. They put them out where the old ones were, where they think they should go. So most of the time they wander in and out, and the deviation is not typically very great. It's a foot or so here or there. If we covered that type of thing on just about every property we insured, then we'd be paying to move fences. And therefore we'd be paying up thousands of dollars while typically taking hundreds, and the math doesn't work for us. So there's no coverage for that. However, again, we can, if the deviation from the lot line is pretty drastic, let's say your clients look at a property, there's a huge backyard, this is wonderful. Turns out later that the rear 15 feet actually belongs to the adjoining landowner. They got carried away when they put the fence up. They would have a claim for the loss of value of that. But we're just not going to move fences, you know, a few feet here and there. It just doesn't make sense. We don't cover misrepresentations by vendors. Then they say the roof's never leaked, the furnace was leaked, 2 years ago, blah, blah, blah. They call them misrepresentations, they call them fraudulent, but we don't cover that type of thing. They're not actionable under contract, but not other ones. And this is more for vacation properties. We don't cover boathouse leases. There's a requirement now. The federal government has been going around the lakes, and there was a requirement for many, many years that they just kind of let slide. But any boathouses that are on the beds of navigable waters, which I imagine would be everyone, because why would you have a boathouse on anything that wasn't navigable? You have to enter into a yearly, enter a lease and pay your yearly rent. And if you've seen those commercials for $6.49, where the families out, like, look at this, and it's actually a cottage, which is a boathouse out on the water. They would be great big rents. So we don't cover that. That's something that we'll just have to look at. And there are limitations of title insurance simply because it's an insurance policy and it has the same limitations as any other. So there may be problems if there is a failure to report a claim on a timely basis. I always forget the time period. Is it 90 days?
Yes.
90 days. I have a very bad time, so we give people 9 days to get it. But if they come back later and that causes us to pay more money, then that may reduce the amount we pay out. We don't cover closing changes in bylaws or government regulations. So I'm sure people will quite often buy properties based on what the surrounding area is like. And they go, gee, the tax on the green space isn't that wonderful. Well, it doesn't always stay green space. So somebody builds an abattoir or a gravel crushing. The gravel crushing will actually happen. Yeah, that down around Windsor, somebody bought a property out in the country. They thought it was wonderful, all the fresh air and that. Somebody put in a gravel crushing. Business right next door and other places covered gravel dust. So no coverage. And post-closing expropriation. There is no right to property under the Constitution. The government's various levels have the right to expropriate your property. The only time that we would, was a failure to pay appropriate compensation based on the title. Other than that, no, they can take it, we can't do anything about it. And there's kind of a trio of title risks that are created or allowed by the insured, that are known or agreed to by the insured, and that result in no actual loss. So if when you're buying a house, you know that there's an encroachment, you're told about that, then we have to be told about it. We will make that an exception in the policy. Even if we aren't told about it, we generally find out when we investigate, because we look at everything. We look at the agreements, purchase and sale. We look at the listing agreement. We look at the seller's property information statement for this one. Terrible documents. We look at everything. So if they know about it, they've agreed to it, then we're covered. If they created it, obviously we're not going to cover it as well. And we had a really interesting situation many years ago, it was north of here, where somebody bought a very large property and subsequently put in a claim saying that the pool in the backyard, the dam, all these things had been made without building permits. Municipality came around, and so we looked into it. And yeah, there's no permit, but we also had satellite imagery of the property when we bought it, and there was nothing there. So they put it in, they got caught, and they thought, well, we'll just put in a claim under title insurance, because obviously they're stupid. So we do actually look at it. And title risks that result in no loss. It is, like all insurance, it's key to financial loss. You have to show that you've lost some money. It isn't hurt feelings or being anxious about something. Had a guy who bought a 0 lot on Henderson, this is around Hamilton. So the deal with this was your, as you probably know, your building basically was on the lot line on one side. And then you would have an easement over that adjoining property and so on all the way along. When the person bought the property, it didn't have the easements. Subsequently, they were put on necessarily. And apparently this caused this individual grave emotional distress. Somebody could be using his property, so he wanted to give us to give him $50,000. So we understood that he had some emotional issues, but there was no loss, so we don't pay. And when people don't like the figures we come up with, we say get your own appraisal. As long as you use an accredited appraiser, not your uncle or your friend Bob, then we'll look at all the appraisals, because that's what we do. We have to do that because if the regulators are looking at us and they look at a file and we don't have the evidence to show that we paid in accordance with whatever was actually lost, we get in a lot of trouble because we're a publicly traded company. If people have stock in it, we can't be giving money. So that's kind of the lack of right in adjoining lands is another more important one, probably in cottage country, but we cover whatever the actual legal title is. Right, so if it's together with a right of way over an adjoining property, that's covered as well. People will quite often buy property and assume they have rights over the adjoining property, and we don't. And they come and say, well, we can't do this. We don't cover that. We don't guarantee your title. We do guarantee access, but it is any access. It's not just the specific access. If they can't get in one way, if they can get in another, well, then we don't need to cover that. There is a process we're going through that's set out in the paper. I really don't think it's necessary to go into that. There's a lot of examples of claims. The first one was missing access. And in this situation, the owners thought they had access by a driveway that they thought was theirs. When the adjoining property was sold, those people got a new survey, and they discovered, oh, the driveway was on their property. So they all of a sudden said, so you can't use it anymore. So their property was, they had the road was alongside of the property, but it was at a different elevation. So we ended up having to spend $9,000 to actually put in the driveway with the elevation. Neighbor problems drive 90-some-odd% of real estate litigation. People get stupid about things. You know, they find out the neighbor's fence is a couple of feet under their property, it's been there 40 years, but all of a sudden it becomes a crisis. And I've gotten called into those situations where they've expected us to pay. They figured out what percentage of the lot it is, so they want us to pay percentage of their property taxes and their insurance and their mortgage, so, and no, it doesn't work like this. Water arrears, there was a municipality in Western Ontario called Windsor, they would say that, who decided that when they were collecting, they would tax us, they would not apply them to water arrears, they apply them to non-legal matters first, and then they let the water arrears run off. This person moved in and then got a bill for $4,900 for past water arrears. So we ended up paying that. I think we're still fighting with Windsor over that because it's kind of serious. CRA deed trust, I'm sure you found that around the deeds before. If somebody has a business and they own property and they aren't submitting their withholding taxes, EI and CPP and so forth, then they can be a deed lien on the property, a deed in trust. And there's the case we have here is basically the amount of claim is over $35,000 because the insured member that's on the property parties went bankrupt. We will cover everything up to the time that the mortgage was put on. So anything after that, they had to cover. So in that particular case, we paid $12,000 to $35,000. So again, that's one thing you understand. We have lots of fraudulent transfers by family members. Some transfers the house to himself and then enters into an agreement with a partner who's also fraudulent. That they're selling the house and they get a mortgage on the property and then we take off with the proceeds. And obviously that was invalid mortgage, so we ended up covering that. Stolen identity, that happens all the time. It's one of the things we were talking about yesterday. These guys have gotten so good, the fraudsters, at forging ID that even the experts quite often can't tell it just looking at it. So we have joined with a company called Stewart that does analysis on all of these multi-faction and so forth, because it's just getting harder and harder all the time. And in some cases, it's just the easiness. There was one situation where where the property was in Alberta, but the people had a BC driver's license with an Alberta address. That doesn't happen. So we've had situations where the pictures on the driver's license obviously didn't bear any resemblance to the parties, because we look at this after the fact. Or that the birthdays where we have a whack that, you know, in Ontario, your birthday is on your deed. So somebody who owns the property is apparently 70, but somebody's mortgaging is 30. So you kind of got to pay attention to that. But I'm not going to go through the rest of this. I think you can get that. I want to talk about fraud because I think that's what you're more interested in. I want to explain how that works. So there are different types of fraud. There's obviously mortgage fraud, and then there's the fraud involving the title of the property. And there's variations on that. Mortgage fraud is relatively easy. As I said, we guarantee the validity, priority, and enforceability of the mortgage. So if a fraudulent mortgage is registered against the property, we do our investigation. And we always want to make sure that the owners aren't actually involved in this, and they're just trying to lay it on. But if we determine that it was a fraudulent mortgage, then we pay it out and the mortgage is discharged. We as an insurer then step into the shoes of the parties that lost the money. It's called subrogation. And if we can get the money back, we try. But very seldom can we can because the money is usually out of the jurisdiction. Very seldom can we ever transfer or trace that. So that's relatively straightforward. In terms of houses, it can be transferred for a variety of reasons. You know, it can be somebody who is a tenant of the property, and they take on the identity of the actual owner, or in many cases they will forge a power of attorney, and they will say in the power of attorney that they are the relatives of the owners, and they have the power to deal with the property. And the idea being that they sell the property, take the funds, and take off. So in that situation, People are always concerned right now, we run into this a lot. Well, somebody's gonna steal my title and I can't get it back, I'm gonna be out in the street. That's not the way it works. If there's a fraudulent transfer of your title, then in this jurisdiction, and it's not the same in every one in the province in Canada, you get the property back. The only time you would lose it is if there's another transfer. So, and that's very unusual. So there'd have to be the fraud artist transfers to an individual, and then that individual transfers to another innocent individual. The term is deferred indefeasibility, it'll be a test. And that's what that means. So that person who is the second, they've got good title to the property. And the thinking is that the first person had more chance to determine that it was a fraud by doing appropriate investigation. Second person did not, because they were buying from a bona fide. Now, we very seldom ever see that. Right? People are transferring title because they want the money, and either by way of mortgage or by the proceeds of the sale, and then they go. Very seldom do we ever see that second transaction. So people should not be so concerned about the value of the policy, because what the policy is covering in most cases is the costs involved in getting the title returned. Right? We've got to get lawyers generally involved. We've got to find out if anybody else, if there's a mortgage issue, so whose insurance was on that, get everybody together, and then we've got to go in many cases to court, get an order to have it returned. If they're really worried about it, we can increase. We've had people calling us saying, my property's gone up in value, we will increase the policy for them and we'll charge an extra premium. Probably not necessary, the risk is very low. So now there are transactions where let's say a couple are having problems and one of them gets a fraudulent imposter to be the other spouse, and they go in and they take off with the proceeds. Well, again, it's an invalid mortgage, and again, we would cover that off. So we pay a lot of it in frauds, much more so recently. And we have, as a company, decided that we will not insure private mortgages over $500,000 because they're just too big a risk at this point in time. We are looking at mechanisms to try and prevent fraud, that's the tree fort and things like that. And if we can get those type of things in wide use, then they give us much more comfort and we can probably increase that. But private mortgages are the area where, in terms of mortgages, where there's the most fraud. Because people, the private mortgage, and I used to do a lot of private mortgage work when I was in practice, I know. And the lenders under private mortgages, they don't care about anything really. All they want is their money out of the property. They don't care too much about the background and so forth, and they'll lend to people generally who can't get it anywhere else. And it tends to end up in a lot of litigation and so forth. And it lends itself to more fraudulent behavior, I think. So any questions about fraud or anything?
I have a question that was brought up from our virtual audience. From Linda Jackson. Question. Taking them, can a homeowner purchase title insurance after owning for many years?
Yes.
And what is the best way for them to find out if they've already got home title insurance on their home?
Well, hopefully they would remember from the time they bought the property. They could certainly check their documentation at that time, and it should tell them. If they purchased the property prior to 1995, thereabouts, something even prior to the 2000s, title insurance has only really become so ubiquitous in the last perhaps 10 or 15 years.
Okay.
Right? So if you don't have it, I mean, it calls quite often from people asking to have title insurance, and because of the PED and all this privacy thing, we have to get a lot of information from them before we can't just go in and go, oh, yeah, we've got it, because they could be asking about something else.
Absolutely.
Now, we do have a product, I think every title insurer has one. It's the existing homeowner policy. and you can buy that. And it basically what it does is it puts the policy date back to the date that you bought the property. So what you're really getting is the post-policy coverage, defensive title and all that, so it's fraud. So to give you an example, my mom lives in Oakville, my mom and dad bought the property there in 1961. My mom still lives in it, they got it for the princely sum of $12,750. It was a good investment. And when I went to work for Stewart, of course, my mom thought, well, I better get title insurance because that would be a big feather in my son's cap and raise and so on and so on. So we weren't going to insure it obviously for $12,750. What we look at is you can get an appraisal. We get a letter of opinion from you guys. We can go with the impact property assessment. Okay. But we want to put that on, and basically that covers them from that point on for anybody that fraudulently might register a mortgage or transfer their title. And we've been selling a lot of those. It wasn't something even initially that we thought. Initially, it was just you either got title insurance when you bought a house or when you put a mortgage on. That was it. But when fraud started to become widely reported, the Toronto Star had an article on it, we get just panicky calls from senior citizens that they want the property sold. So that's available. It's a long-winded answer.
No, that's.
I'm good at long-winded answers.
So I think you answered this question, but just to clarify, the amount of your policy, the amount, like say you bought a house 20 years ago and prices are up tenfold since then.
Yeah.
The amount doesn't necessarily matter. I guess it falls within your duty to defend title, is that it?
Yeah, I mean, it's unlike, and I don't want to say, I can't say categorically it'll never happen, because you could have that secondary transfer, but the chances are fairly low. And, if you've got the policy's up until when did the 400% was just turn limit?
They did the 400% December 16th.
Okay, so it was 200 up to then, all the new policies are 400. So, you can come to us and we can do an approve an endorsement. You give us a valuation of the property and we will attach that and we will just calculate the additional premiums.
But in general, that duty to defend is what actually matters, because even if, let's say they're insured for $250,000 and their house is 1.2.
It's
Your duty to defend in order to get title back to them really doesn't, like the value of the property really doesn't matter in that.
Yeah, it's unlikely we're going to spend anywhere close to that. So, I mean, I don't want to chase business today, but by the same token, I don't want people to be freaking out over.
Is the, sorry, is there a question over there? Go ahead.
So you get title insurance when you get the mortgage. Once the mortgage is discharged, does the title insurance still carry on the house?
Well, there are two different policies. So there'll be a policy for the owner and there'll be a policy for the lender, and they're different. So the insurance policy for the lender, if it's discharged, is gone. If it's assigned, like I said, it will continue. The owner's policy, and this is something else I should mention as well. The owner's policy can continue if the property is transferred to children or to the spouse and so forth. So it can go on even if it was in a trust to the trustee. The one thing it doesn't cover is transfers and the unlikely event from the children to the parents.
So the two policy aspects, if you discharge your mortgage and then 5 years later get a mortgage, does a financial institution typically get title insurance at that point as well?
Yeah. That's the refinances, almost always is a requirement of and the title insurance premium for refinances is very low. So it just makes sense for them, because if you didn't, then the lawyer is going to have to do full search, they have to order all of the off-title searches, they're going to have to worry about surveys and things like that. And typically it's way more expensive.
And is that a new policy for the homeowner at that time as well, or just the lender?
Just the homeowner's policy could get, yeah.
So typically, most of our buyers will have mortgage title insurance put on by the lender as opposed to owner's title
Yeah,
insurance.
what will happen is basically the instructions will go to the lawyer that's acting on the
Yeah.
purchase, and the lawyer that's acting on the purchase will order both at the same time. So
Okay.
it's less expensive when that's done, when you order one policy, then the next policy is $50.
Okay, so
Rather, if you order them separately, they'd be more, so they usually do it all.
we usually both of them are on the property. Okay,
So you talked about two frauds, you talked about title fraud and you talked about mortgage fraud.
Mhm.
So in the case of title fraud, the owner is the insured. In the case of mortgage fraud, is it the lender that's the insured then at that point?
That's right.
So the owner really isn't affected, it's just,
Well, they are to the extent that, I mean, it's a common interest.
Right,
They don't
of
know,
course.
they don't know
Yes.
what you're doing
Yeah.
the policy, but, you know, we don't treat them differently simply because it's the same.
anybody else got any questions? Christian?
Just going back to the survey comment. So are buyers still better off not seeing the survey, not even trying to search for it?
This is a question that comes up quite often, and there's been varying opinions on, there is a lawyer that feels that you should have. He writes for the Toronto Star, he probably spelling right. He writes columns on real estate, and he's on record as saying that you should always have a survey on a property. It can be useful, but it depends. And like everything, it depends on the facts. So, you know, for instance, it might be good to have a survey to discover whether or not you can do what you want to do, right? Maybe you want to put in a swimming pool, you want to build a garage, you get an addition, whatever. So having a survey might be useful, but if it isn't a condition of the agreement of purchase and sale that you're able to do that, then you get a survey and you find out you can't, so can't get out of the deal. Right? So, and the other side of that is that if it discloses an issue, quite often people still won't buy anyways, they love the property, they go, well, you know, it's going to limit the title insurance coverage that you get because it's a known issue. So let's say the survey shows that the garage encroaches, you know, 3 or 4 feet onto the adjoining property. In the absence of a survey, you don't have full coverage for that. But if you're going to cover it, it's going to be more limited, it's going to be forced removal coverage. So, surveys can be useful. I think it's something that should be discussed early on so that if it's something that they want to make conditional, you guys should know about it and put it in as a condition in the agreement. And sometimes people just want to know the size of their property. It can be useful as well, I suppose. But,
As a schedule.
sorry?
Get the survey and don't put it as a schedule, just keep it for the buyer.
Well, we're gonna look at it anyways,
Yeah.
so, I mean, you know, when we have a claim, we look at pretty much everything. Yeah, and, you know, quite often, one of the things we find is that the lawyer never got the survey. That it was given, an existing survey was given by the owner to the purchaser, or maybe through, you know, through the agents, whatever, they never went to the, and it turns out there's a problem. In that case, we haven't, as far as I know, held that against the insured, because the lawyer wasn't aware of it, but we could conceivably say, well, we knew that this was, it's on the survey, we knew that we had this problem. So I find generally surveys tend to create more problems than they solve. You know, people get bent out of shape, like the one example I gave, and this was down where I live in a little town called Stratford, between London and Sarnia. And a property in Sarnia, people have lived there for 10 or 15 years, and then got into a row with the neighbor and got a survey and discovered that the fence along what they thought was the lot limit bowed in a little bit. So the middle was about 2 feet in, and that caused an existential crisis for this guy. I spent lots of time on the phone trying to explain to him that there isn't really any loss of value, so we really can't do anything for you because you wanted us to pay tons of money because of that. So we're even better off without the survey.
are there any differences or implications between an individual buying a property or company buying a property in terms of title insurance?
No, not really.
Or commercial properties versus residential properties?
Well, I would say there's always, commercial policies are quite a bit different in the coverage they have, there's limits on lots of things from there. depending on the amount. And that would be a whole nother session to look into, but it's quite a bit different. I think there's typically commercial policies cost more. And they typically have less coverage, I think it's safe to say.
Why is it here? There are lots of questions before. Go ahead, Kristen.
With the searches that the lawyers used to do compared to the ones that do now, what are the basic changes, like, especially the one that you mentioned about the open building permits that actually happened?
Yeah, well, you know, normally, I mean, and again, it depends on the property, where you're on and so forth, but, you know, without title insurance, lawyer would not only be looking at all of the documents, how do we do a search of title? Which in and of itself is quite a bit of work if you do it properly. But then they would be looking at all of the, you know, the local municipal searches, maybe provincial searches, depending on the type of property. And of course, if it's not a condo, I mean, if it's a condo, then obviously you're looking at the status certificate and all the condominium documents. People have this tendency to think that condos are less work, and they're more. There's much more stuff to read with condos and stuff to go through. And that's why, you know, there used to be tariffs for lawyers, condos have higher tariff than detached homes. But all of those things have to be looked at, and then, you know, they can be quite expensive. I have no idea what the municipal searches are now, but when I left practice in 2001, in Oakville, here in London, they were about $150. So I'm assuming they're probably $300 or $400 now. We don't require those for single family houses. So that's a big savings, and for multifamily, we do require from 2 to 6 units. We do require a building and zoning and a fire department work order. And the building and zoning is what you would find out, whether there's an open building permit or there's any work orders or so. For single family houses, yeah, we have lots of claims that come in for open building permits.
So on that example you gave with the multiplex, would we actually have to make it conditional on getting the approval of title insurance to be put on the property?
I mean, I understand there's been a reluctance to put any conditions on things. And, you know, normally the problem would be not so much the ability to get or not get title insurance, because title insurance is not mandatory, there's no legal requirement to have title insurance. An individual can ask the lawyer, if the lawyer is willing to do it, to just do it as a traditional title deed. But I think you'll find most lawyers don't want to do it because they don't have the time. Getting the reports from the municipality, particularly the last 3 years during COVID, have been a real nightmare. And they've always been there. I used to have fights with them all the time. Didn't matter how much time we gave them, we'd always come in late. So you can do, you know, you can do that if you wish. I think the real problem would be if you can't title insure it, or somebody won't, then the lender won't advance the money. And that's what the problem. So, you know, I think there should always be financial conditions, because most of my friends are lawyers, like, you know, I talk with them, and a lot of them are dealing with issues where the client couldn't get the mortgage. Now they're being sued for hundreds of thousands of dollars. So, I don't know if that answers your question. Yeah.
One question, maybe just on status certificate for the condominiums. There's been a few where some of the lawyers actually missed things, and we found out later the possibilities of having repercussions down the road. So does the title insurance actually cover the status certificate?
Well, it depends on exactly what it is, but typically, yes. I mean, we do cover anything that affects the title of the property. And most of our policies have something attached to it called a closing protection letter, which covers basically errors and omissions that might occur if the lawyer missed something that otherwise wasn't covered. So it covers it off even more. So, you know, I mean, what we get a lot of calls about, for instance, would be you know, special assessments that arise after closing.
Exactly.
And if you know, look at the status certificate, it doesn't say anything about it. Well, that's the chance you take. I used to tell my clients with condos, by the way, I hate condos. I never lived in one. I used to tell my clients, like, this is, everything is fine now, but they can have a meeting 2 days from now and decide to impose a special assessment. And there's nothing I can do about it. So go to all the meetings, make sure you vote, people. And then you get a special assessment. And then they'll say, well, they were talking about it. Well, it wasn't revealed. Nothing we can do about it at that time. If it has been something that was in the certificate that the Lord missed, then you're wrong.
And that special assessment was imposed from the time of purchase to the time of closing. Would that be covered?
Oh, if it was something that they became aware of, yeah. I mean, they should, because if they bought the property, then they ordered the status certificate, so it should be revealed to them.
And what I'm saying, if you have a 90-day closing, and you bought a property today, it's firm, 30 days time, there's a special assessment.
Okay, but again, when you get your status certificate, I mean, if it's early on, then obviously, when you post something after the fact, then there could be an issue with that. Like, it depends on the facts, but typically, most of the time, you're gonna get your status certificate somewhere in the middle. We have timelines for status certificates. If it's within 30 days, we don't care about it. If it's 30 to 60 days, we just ask you to follow and see if you get a verbal update from the condo corporation or the property manager. And you just make a note in the file and told me there was no issue, or told me to go fish, in which case we'll still cover you. If it's 60 to 90 days out, then you have to get a verbal. And if you can't, then you get a new status certificate.
In your opinion, for seniors and for their protection now, with all this on the news, would it be better to get the title insurance? Or what I've been hearing, to get financing on it?
Well, yeah, that's what something's been kicking around for years. People say they're less likely, and it is true. Fraud artists are less likely to go to properties that have a mortgage on them, but it's not unheard of. I mean, when you think of it, if they're going to register fraudulent transfers, they can register fraudulent discharges of mortgage too.
I think I heard on the news not too long ago that somebody found out that their family's property, or that their property, I think had been sold out from under them, and the fraudsters had paid off whatever mortgage they had out there.
I mean, one of the things that we talk about with lawyers and everybody in terms of fraud is, you look at the title, have there been recent discharges of mortgage? Well, then that's a suspicious thing to look at. But in answer to your question, that in and of itself doesn't really help. I think title insurance is much more cost effective than doing a mortgage on your property.
And roughly, what would the cost be to something like $1 million property nowadays?
Let's see, it's existing homeowner policies and static up to 750 is my time.
Similar, I can give you a price.
Generally, what they run, 1,000?
Oh, and I would think it would probably be what, $1,500 for $1 million or something like that. I'm so far, I'm not in that.
Just get an idea. So a lot of seniors are asking.
Depending on it depends, I'd say probably about 750. It depends, yeah. But I can send you the price list
Yes,
so that
that'd
you'll
be great.
have exactly.
Yeah, just to know. Because there's a question being asked quite a bit nowadays.
Yeah, I'll send it to you as consistent
Yeah,
homeowners.
had that question yesterday. And somebody asked, is there anything we can register on title to prevent that? And no, I mean, we can register cautions on title, but individuals can't do that. The government does that if there's a problem. And one of the things has been, one of the things that you said was, we'll register a mortgage on, get a line of credit
Yeah.
on it on there and stuff. But it doesn't prevent it, it just makes it less likely, and really, why have a mortgage if you don't need it? So I think it makes more sense just to have the title insurance policy, so.
I just, but didn't know the difference.
I don't think they're that expensive, I think we should charge more money.
With everything going on and with all the claims being made and all the money that's being paid out, I find it fascinating. I go and I make a purchase on my credit card, and I'll get an email saying, you just made a purchase on your credit card. I have a debit card that I can actually lock, so that if it's a debit card I don't use, or it's an American card or whatever, I can actually lock it and then unlock it when I know I'm going to be using it. with all of this going on, are there any conversations among insurers or regulators or anything to sort of add features for consumers to be able to protect themselves?
There's always discussions between us and the legal profession and the government and the regulators. You know, there's so many people involved. You know, the registry office, the director of titles is a fellow named Jeff Len, well-known lawyer. And so they've got their policies as to what they will and will not do. The regulators have their own. The province again has their own agenda. It isn't something I think anybody's really done any. I think there'll be probably more changes because of the increase in fraud. It's become much more apparent recently, much more newsworthy, and that tends to poke the bear, so to speak. So I imagine there may be something coming along. But you know, we love to see all sorts of things because we're the ones that pay out at the end. And of course, if you're not paying out, then they have less concern. You know, they talk about things being invasive, and you know, one of the things that comes up with the programs like Tree Fort and others is that they look at things like banking information, because just looking at identification in and of itself isn't enough. I mean, you can be really good at that. So, you know, you ask a person about their banking, and then you can see if they know if credit cards are coming out or mortgage payments are coming out or whatever, you can get a better idea about them. But at the same time, people are being told, don't give your banking information to anybody. Right, so then we say, well, why should I give it to people? Well, we're trying to prevent, it's not us, but companies say we're trying to prevent people from defrauding you. You know, so we've got all these competing interests, and there's a real requirement of privacy right now. We can't, it used to be, we share more information, can't tell anybody anything about anything. It's a competing.
Yeah, I find it, I mean, it's one of those things of like even a homeowner being able to register for alerts on things that happen to their property, things like that.
I mean, it would be great, I think, if you could put something on title and say, hey, let me know if anything goes on title. That would be something that the government, the Ontario, because under our constitution, property and civil rights are provincial matters, so the Ontario government, right, would have to institute that. And I don't know what the cost would be for that, because obviously they charge for it. So, but yeah, I think it would be a great idea.
Just a little clarification on the future use that we use on our offers. You said you would cover it, that thing called correct.
Not future use, you cover the existing use. So whatever you buy, right? If you buy a fourplex, then that's what we're guaranteeing is a fourplex. You know, people then try to sneak in a fifth, and then they get hammered by the municipality. Well, we're not going to guarantee that. We're going to guarantee whatever the existing use is. If you want to change it from, you know, residential to commercial, we can't do that. And you know, typically, as a lawyer, if somebody comes to me, I'm not going to be able to do that unless you instruct me ahead of time. Find out if I can change this. This is the agreement's conditional on me being able to use it as this. Then I'd have to do all the searches. I'd have to talk to the municipality, I'd have to do the zoning searches, and then we have to talk to see if they allow a change in use. So it can be quite involved.
And the defects you mentioned that you would still cover, those would, whenever it's caught, would now actually be an exception from the policy, right?
Well, if you're talking about something that is known ahead of time, then yeah. I mean, it either would be excluded or it would be, okay, the coverage would be limited. And this is where it's better to tell us. Because if you tell us about an issue, then we may give you some coverage. If you don't tell us, then there's no coverage. We can't retroactively put coverage in the policy just to cover something, right? The regulators will get very angry with us about that. So if you know there's an encroachment, tell us, and we'll probably put some coverage in the policy.
Okay, but you still do the policy. I know some people go, yes, fine, I don't care.
Yeah.
Fence goes completely along the way or whatever, they still want the property.
You
They
know,
want to finance it too, so it's like,
yeah, you know, but I mean, they have, lawyers, you know, will tell them, you know, look, this is an issue, this is what we should put in there. And that's why we look at everything, because people, you know, people being people, they try to slug things through all the time.
Any other questions or? Good, I can't see from the post. Steve, do you have any?
One last little one.
Yeah.
Regarding the open permits, is the lawyer better off trying to make sure they're not open or just sort of blanket to board?
Well, it's an expensive search. In most cases, and quite often it's hard to get them back in time. I mean, it is required for multi-family properties. For single-family properties, it's probably less of an issue. But the leading case on that in Ontario, basically, it's an odd case back in 2013. It's one that deals with paragraph 10 of the agreement of purchase and sale, and that's the one that says title insurance can be an answer for requisitions. And the situation was a property where there was an agreement of purchase and sale, and the person that was acting for the purchaser decided to do a building and zoning search. Didn't have to, but they decided to do one. Discovered that there was an open permit. And then they said to your insurer, will you cover it? No. It's a known issue. We have no idea what's involved with an open permit. It could cost $1,000, $100,000, could be anything. And then they requisitioned it. We happen to be the insurer of choice for the vendor, and the vendor spoke to us and said, here's the deal. We've got this open permit, but everything's been done. We've got all of the receipts for it, et cetera. They haven't inspected it, or they haven't administratively removed it. Would you get coverage? Well, we'll agree there's $100,000 deposit. We'll agree it won't be released until the permit is closed. And we said, yeah, we'll cover it in that case. And the lawyer said, basically so they didn't hear about it until too late, and then they said, no, we're not going to accept that. They brought an action to get their deposit back, and the court said, no, the agreement says title insurance can be an answer. You got title insurance was offered to you, because you lost your $100,000 deposit. And by the way, you also are responsible for court costs. And they didn't like that, and they went to the Court of Appeal in Ontario, which is high as you can get, because the Supreme Court of Canada is not hearing real estate case. And the Court of Appeal said, yeah, that's the law. By the way, they owe another $8,500 in court.
That's what happened to me. So, so would it have been better for the purchaser just to get title insurance? That's it.
Would have been less work.
Okay, that was my whole question, because the home inspector said, why don't you take a look at there's open work orders and where it did, and open things up from 20 years ago.
Yeah, well, I mean, if there's an open permit and then somebody does something about it, then yeah, we're going to respond to it. And typically, we don't get the municipality directly involved if it's not known. We're going to hire an engineer to go in and see what needs to be done. Then we'll do it, and then we'll have an inspection. We don't want to give the municipality a chance to do it. Can we get out of this? So there's a lot going on. That's one of the leading cases.
Okay.
And that's one that's quoted all the time because of that paragraph 10, which was a big change. It never used to say that. The agreement used to say that if there was a requisition that was valid requisition that was made, which the vendor was unwilling or unable to remove, remedy, or then the deal was at an end. The deposit will be returned in full, etc. Now it says or obtained. It's very badly worded, but it says basically obtain title insurance.
I think that changed a lot of things.
Well, I think it makes it easier for things to close.
Yeah.
Right? Because that's one of the things about title insurance, minor issues, then you can cover that off. Now, there are limitations to that. The one I like to use, we do these programs for people. We have a sample survey that shows a pool encroaching about 7 or 8 feet onto a high road. And the question I say is, do you think title insurance would cover that off if it was a known issue? It would give the lender coverage if there's sufficient equity, but it wouldn't give full coverage to the owner. It would give them coverage for forced removal, which is different than marketability and everything. So you could not force using section 10. So there are limitations.
It's very common, actually. When we hydroplane.
Yeah. And frankly, I don't know that I want to body water next to high tension cables. So, but it could be, it depends on the nature of the easement. They could force you to tear the pool up and do all sorts of things. So normally, not something I want.
Little shocking.
All right, I think we've covered
Yeah.
everybody on screen and everybody here. Thank you
Thank you
so
very much.
much.
Thank you.
It's really cleared up a lot of questions that we've had. And it's a real hot topic for us with our clients,
Well,
so,
people have this tendency to say, title insurance.
yeah.
You know, one where there was a boundary dispute, the neighbors were involved in the litigation. And, then the purchaser was told, just don't worry, just title insurance. Well, no. There's existing litigation, no, we're not. It's better to know the limitations of.
Yeah.
Not really so.
Absolutely,
That's great.
great.
Well, I didn't know I'm staying late this long. so.
Very interesting.
Thank you.
Thank you very much.
Yeah, okay.
So should we send it to the- Okay, I found it right here.
How are you gonna send it?
Yeah, it depends.
Or
Well, that's what you get when you.
Yeah.
I was asking,
yeah, they all want.
so
That's right.
from 0 to 500,
Actually, they are.
it was just,
You can
and then
use
anything
it
over
other
it's